Salute you all. Thanks for watching. Subscribe and like the videos. So today's topic of emphasis, or the topic of concern that we are going to look at today, we are looking at company law. You understand? We are looking at company law, and what you have to bear in mind under company law, okay, it's like the law of business associations. That is the topic, that the course unit that we are looking at. And basically today's topic of emphasis, or the topic that we are going to instill deeply, we are going to look at what is a company and the types and categories of a company in this clip. Basically what you have to put in mind, or what you have to bear in mind, one of the things you must know what is a company, where does the word company comes from. Basically a company comes from the word, is it companies, which means people sharing together. You understand? Where people come and share what? And share together. That's the point that I'm trying to bring out. And what you have to bear a good definition of a company, realize that different case law define what is a company. There's a case of Centamo versus UCB. That case defines what is a company. Salmon versus Salmon defines what is a company. But before going any further, what you have to know that a company is a legal entity. You understand the definition? A company can be defined as a legal what? A legal entity, a body separate and set apart from its members or shareholders. You understand? Basically, this definition, what I'm trying to bring is that it defines a company as a person. Actually, it is distinct, or it is separate from its members or shareholders. A company stands as a company. It is a legal personality. We shall look at corporate personality as we move in front there. Corporate personality. Just know that a company is a legal person, and basically can be sued and can sue in its own what? In its own name. You understand? That's what I can give about a company. Also relate to section 1 of the Companies Act of 2012. They doesn't bring that vivid description out, but they define what a company is. Basically, for them, they defined as it is something that is brought up by what? By registration procedures, or by registration, anything that is registered is a company. But that's the preamble part that I can give you of what a company is. But remember, a company has different functions, as we may see. What you have to bear in mind, a company has different and various what? Functions. And basically it is the major point of the company is to make profits for the owners or for the members. For example, private companies, we shall see the types of companies in making profits. That's the general aim, to make profits, public investments, among others. You get? So basically that's one of the functions or the purposes of a company. You get? And to carry out trade purposes. That's what I can give you as a preamble. And what you have to know about this essence is that a company, the types, before even going to the parts that in a way that when a company is running financial problems, the creditors can be compensated from the members' what? Contributions. You understand? And basically not that. You get? Not that. It also acts in a company limited by what? By shares. You get? Limited by shares. Not that. And unlimited, even they pay for the remaining debts, as we shall see in front there. And we go to the types of the companies. When you follow section 4, subsection 1 of the Companies Act, provides the types of a company. We have two types. You have the private company and the public company. What do I mean by these two? So basically what we are on, or what we are moving on, is that private, I'll start with the private company. A private company is provided under section 5 of the Companies Act, section 5. And when you read section 5, it provides that a private company is a company which limits its members to doesn't exceed 100 members. That is a private company. and also it restricts its articles of association or the articles of memorandum restrict the transfer or the right to transfer shares to the public. That is for a private what? A private company. And there is a case of Lutaya versus Gandesha. The case of Lutaya versus Gandesha, whereby the man and the wife formed the company, and it had over 1,500 shares, and the wife held only 2 shares, the rest were for the man. This was also a company. You understand? For a private company, what you have to know is that it can also have only 1 director. But for a public company, it must have more than 1 director. But for a private, it can start business with 1 director. Put that in mind. And also, we are under private company, whereby 2 or more persons hold 1 or more shares in a company jointly, they shall be taken, presumed to be 1 member. So put that in mind when you read section 4, subsection 2 of the Companies Act 2012. It provides for that. Then when you go further, that for it, we have seen that it prohibits invitations of buying shares from the what? From the public. But nevertheless, we realize and we see that these companies, you understand, for them immediately, once it starts business immediately after incorporation, unlike public what? Companies. For private, it starts immediately after incorporation or immediately after registration. You understand? So bear that in mind. That is for private what? A private company. So when we also go further, we go to the public company. When you say public company, it is provided under section 6 of the Companies Act, which means that a company which is non-private is a public what? Company. But however, a public company has tell you that what you have to know, that the memorandum of its association must state that it is to be a public company, and its registered name normally ends with the words public limited company. You understand? So put that in mind. For a public company, the memorandum of association must contain the description. And what you have to bear in mind, that a public company must have at least 2 directors, not like a private company which has only 1 director. For a public, for a public company may offer its shares or debentures to the general public for subscription. We saw MTN where it sold its shares to the public. We have seen many companies inviting the public to buy shares. So that is a public what? Company. You get? And what you have to bear in mind, any company that is registered to be a public on its original what? Incorporation may not do business nor exercise what? Any borrowing powers unless they are provided a memorandum of associations and articles of associations. You understand? They are key, as we shall see them. Memorandum and association, those are documents that are needed for incorporation of what? Of a company. And the public companies have a right to raise capital from the what? From the public. And what you have to bear in mind for a public company, for it, basically what you have to know, it invites the public to buy shares, as we have seen, and its memorandum can also alter and exclude the restriction on the transfer of what? Shares. They may put the shares that are to be sold among others, but that's the difference between the two, between a private and a public what? A public company. So put that in mind, or bear that in mind. So when we go further, we have what they call limited and unlimited liability companies. Remember, when you follow section 4, subsection 2 of the Companies Act, for it provides that a company, whether public or private, may be limited by shares, may be limited by a guarantee, or may be unlimited company, Whether you are public or private, you have to have the category that you fall in. You understand? So I'll start explaining by a company limited by shares. A company limited by shares following the description or the authority that's given in Section 4, subsection 2 of the Companies Act. Realize that a company limited by share, this is a company whose memorandum of association limits the liability of its members to the amount unpaid on their what? On their share. What do I mean here? Or a company limited by its shares that the limits the ability of its members are only, you understand, all their members are only liable to the amount of the unpaid what? Unpaid shares. If at all you have a share but you have that unpaid shares, you are only liable to that amount. You are limited by your shares. So the company's debts, you understand, are paid using your what? Your member contributions. You understand? Unlike unlimited shares. So put that in mind. Then we have a company limited by a guarantee. What do we mean by a company limited by guarantee? Here, basically, what you have to mean is that they look at the liability of members is limited. You understand? Is limited to such an amount as they may have taken to contribute to the assets of the company in the event of it being wound up or winded up. Wound up is like to close the company. It's like forfeiture, to close the company. Winding up, we shall see it also in front there, we shall see it. So put that in mind or bear that also in mind. Here for by guarantee, the members or the liability of members is only limited to such an amount that they may have undertaken to contribute to the assets of the what? Of the company in the events of winding up or wound up. The good example I can give of charitable organizations, religious institutions, the research institutions, those are some of the examples that fall in that what? In that category. Then we have unlimited liability companies. Here, unlimited liability companies, this is where there is no limit on the liability of members. There is no limit. The members are therefore liable for all the company debts on winding up, regardless that you had this, you contributed this amount of shares. Once the debts come on the table, when the company is winding up, you are all entitled to pay those what? To pay those debts as members of the what? Of the company. So put that in mind or bear that in mind about unlimited liability what? Companies. Then there's also what they call, they also call holding and subsidiary companies. What do I mean by holding and subsidiary companies? When you read sections, it's section 161 of the Companies Act provides for a holding and a subsidiary company. What do I mean by a holding and a subsidiary? A holding is a holding company. These are companies that have shares or have majority shares in another what? In another company. So that becomes a holding company. You understand? Or whereby its memorandum of association gives it express power to do what? To do so. You understand? So bear that in mind. You get? So a subsidiary company, now it's that one that where this holding company is having what? Shares. You get? So basically note that in mind. You get? That is a subsidiary. It's like subsidiary, as you hear the word subsidiary, it's like a branch, you understand, of the other company, of the holding company. So put that in mind. Read verbatim this section 161 of the Companies Act. You get? So basically that section gives the vivid what? Explanation of that whole definition, or the two companies. The companies, those two companies stand in the relationship of holding a subsidiary, with the holding company being the one that holds the majority shareholding in the other company, which is the subsidiary what? Company. So put that in mind and bear that also in mind. You get? So that is some of the brief preamble or explanation that I can give about company law, as we shall look at our next what? Scenarios. Thank you for watching and thanks for listening. Stay blessed and